And we are recording.
Great. Call this meeting to order, 4:02 p.m. Sunshine Ordinance Task Force. Let's call roll.
Chair Wolf?
Here.
Chair Wolf present. Member Forsley? Member Forsley? Member Forsley not present. Member Neighbors?
Present.
Member Neighbors present. Member Highland not present. Member Yankee?
Present. Member Highland present.
Oh, you are here. Oh, okay.
Thank you.
I apologize. I didn't think you were here. Member Yankee's here. Member, yeah. Member Stein?
Here.
Member Stein present. Member Wong? Member Wong?
Here.
Member Wong present. Member Padmanabhan?
Present.
Member Padmanabhan present. Member LaHood?
Present.
Member LaHood present. Member Schmidt?
Present.
Member Schmidt present. We have a quorum.
Okay, thank you.
Shall I read remote access into information?
Yes.
Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Wolf, did you want to read meeting decorum?
I will read it. Thank you. Also want to add, if you wish to make a statement during general public comment, please press *6 to unmute your telephone to speak. This is for any area regarding that we have public comment. And you can then also press *6 again to mute your telephone once you are done with your statement. We appreciate your self-facilitation on that. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Okay, let's call first item.
Well, it's call to order, roll call, and agenda changes. I am not aware of any agenda changes. Is anybody else? I'm sorry, I didn't hear that.
Any changes or adjustments to the agenda? Okay, seeing none, let's call the next item.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force May 5, 2021 meeting. So these minutes were not approved in June because it was not the correct version of the minutes. However, the correct version is included in today's agenda.
Okay, folks, any changes or adjustments to these updated minutes?
Just a quick question, not on this, but I noticed that the agenda, this is Vice Chair Yankee, had shall the SOTF waive complaint procedures as part of item 1. Is that something we need to do? Or
No.
No, this agenda does not have more than 2 files for the same.
It was originally included because there were more files, but those got rescheduled.
Yeah, we're going to leave that on the agenda anyway, just in case it's there all to form anyway.
got it. Okay.
All right. Continuing minutes. Any changes or adjustments to the minutes?
I have a copy of the minutes. If anybody wants to make comment, I can write it down.
Can I, or we're on to the June ones?
No, May.
May.
Sorry. I'll hold my comment.
Okay. All right, hearing none, let's open it for public comment.
Yes, please.
One moment.
Yes, please. Can you hear me?
Yes, just a moment, Mr. Warfield.
Thank you.
Okay, while Mr. Leger is getting ready, just want to announce that during all public comment, you will hear a chime at the 30-second mark when there's 30 seconds left of your testimony period. That way you won't be interrupted with another voice.
Are we ready? Mr. Warfield,
Yes.
you may begin.
You're going to tell me when to start?
Go ahead. I said you may begin.
I didn't understand. Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com. Also at P.O. Box 170544, San Francisco, California 94117-0544. First of all, thank you to the chair for making that announcement about a chime. I'm not sure how it's going to end, but it would be great if there was, well, some other sound that's, as you say, not a human voice, which is kind of interrupting, and I think that's an improvement. I hope there is a concluding sound as well, rather than a voice. First of all, I would like to once again request that the correct and not the incorrect contact information be specifically noted as needing to be put into the minutes. I think I give it correctly when I speak it, and that is in the May minutes you have P.O. Box 1 space 70544. That should be together as one number. And then on the zip code, you have left off the 4-digit extension. So it reads 94117 when it should read 94117-0544. I would appreciate if you would explicitly make those corrections and have those in the minutes where it can be clearly understood what the correction actually is. I'd also like, as I have repeatedly said, to have all of that information, as I stated, whenever I make public comment. There's a problem with remote meetings, which is quite a difference from in-person meetings, and that is nobody can approach anybody and say, we'd like to talk about this or that matter with you or an aspect of what you said. It goes both ways. I can't approach others. They can't approach us. I'd also like to have the Library Users Association, if not the contact information associated with my name, and in particular that will come up where the where our complaint was heard, where it says the petitioner was Peter Warfield. In fact, the petitioner was Library Users Association, and so the write-up should say that Peter Warfield, Executive Director of Library Users Association, said what your minutes say I said with regard to the case. Thanks very much.
Do we have other public comments?
Yes, please.
Are you ready, sir?
Yes, I am.
And
Thank you. This is anonymous. I just wanted to say something is wrong with the conference call line. It's very hard to hear Ms. Leger, and sometimes there's various echoes and things going on. That's all. Thank you.
All the phone callers, before we move on, all the phone callers, please mute your lines, or I will do it for you. Press *6.
Is there further public comment?
You may unmute yourself if you want to speak by pressing *6 again. Okay, last call for public comment on the minutes for
this
For May
file
5th.
1415. Maybe I'm out of order at this time. I don't
Yeah.
know for sure.
No, we're doing the minutes for May 5th right now.
Oh, I'm out of order. I'm sorry.
No problem. Okay, hearing no more public comment is closed. Is there any further discussion on the minutes? If not, is there a motion? Is there a motion to approve the minutes?
This is Member Wong. I'll move to approve the minutes from May 2021.
Okay, is there a second?
This is Member LaHood. I'll second.
Okay, moved by Member Wong, second by Member LaHood. For all the comments, please call roll.
Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley? Member Forsley?
Absent, move on.
Member Forsley absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Highland? Member Highland?
Can't hear you. *6 to unmute if you're on the phone, Chris.
All right. Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the minutes from May 5th, 2021 has passed.
Okay, thank you.
You can add Member Highland as an aye. I managed to mute too late.
Yeah, we got it. Thank you.
All right, thank you. Thanks.
Let's call the next item.
Item number 3, approval of the minutes from the Sunshine Ordinance Task Force, June 2nd, 2021 meeting.
Okay, any changes or adjustments to this?
I have one.
Member LaHood?
What is it?
Yes. I noticed in the June minutes that the library users 2004 email address should be at yahoo.com, not at gmail.com. I think this might have been copied from a previous incorrect version.
No, I got Mr. Warfield's email asking me to correct the May and June minutes, and I did that in the system.
They're different. One says Yahoo and one says Gmail.
Yeah, I know. I know.
Okay.
So which is the correct one?
The one in the agenda in the packet is not correct. I heard from Mr. Warfield, I believe, this morning, and I made the change.
Okay. As long as you're aware of it. Thank you.
Yeah.
Okay. Any other changes or adjustments? Okay, let's move public comment. Public comment.
Yes, please. Can you hear me?
Yes, just a moment.
Thank you.
Are you ready, Mr. Warfield?
Yes.
Go ahead, sir.
This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com, as I have said many times before, and also at P.O. Box 170544, San Francisco, California 94117-0544. I appreciate Member LaHood's anticipating or noticing that there was a problem with the email address. I believe there was a problem with the May email address as well previously, but somewhere in its life as a draft document, it may have changed. And I'm a little uncomfortable with changes that are not acknowledged in the minutes. I think the appropriate thing to do, while I appreciate the administrator saying that she has changed this, I looked at these minutes earlier today, and they had the wrong email address. That means they had been published for more than a month with the wrong email address, which, as far as I'm concerned, is worse than no email address, because it means that somebody using it might try and reach us and fail and say, well, I guess whatever they might say and give up. If they didn't have anything, they might go and search for it somewhere. So I would appreciate, and I think it's important, that the correction be done as a correction to something that was published for over a month, and specify what the correction is. I would appreciate that very much. In addition, I would appreciate having the relationship with Library Users Association in every appearance of my name in public comments when I have given it, as well as the contact information, which apparently you don't seem to want to do. But I haven't heard any explanation for why at the full task force. It seems to be a policy or some kind of a thing that is unspoken and not answered when I have requested what's happening. In addition, I noticed that my apologies, it wasn't in May, it was in June that we presented our complaint number 20082, library users against the Library Commission. And so where the minutes on item 5 say Peter Warfield's petitioner, no, the petitioner was Library Users Association, of which I'm the executive director, and so it should say Peter Warfield, executive director of Library Users Association, provided a summary and so on and so forth. So other than that, that's all that I have time for, but I think that should do it and make the minutes accurate and documented and voted on. Thank you.
Do we have other public commenters?
Yes, anonymous, please.
You ready, sir?
I am.
Go ahead.
Thank you very much. This is anonymous. I think that you should not use anonymous number 2, and anonymous number 3, just like you shouldn't use male anonymous versus female anonymous. The trying to guess whose accent is who hasn't actually been accurate in the June minutes. So I think you should probably do what other commissions do, which is just say anonymous speaker said this, anonymous speaker said this, or make it accurate as to who is who in that minute. But I think that would be very hard, and it requires guessing whose accent is whose. So I think it should just say anonymous speaker said this and that, because there were at least 3 of us. And right now it's not correct or consistent. Thank you.
Please call for any other public commenters.
Hi, this is Mark Price-Wolf with the City Attorney's Office. I wasn't able to join the meeting via Teams. I don't know, I didn't get an invite. I just wanted to let you know that I'm on the call and be listening.
Okay, thank you.
Mm-hmm.
Okay, last call for public comment. Okay, hearing no public comment is closed. I just want to respond to the last speaker with regards to seeking to trying to identify who anonymous speakers are. What what any one or another commission does in their practice is no bearing on what we do here to assure compliance or reasonable process. There's no law or rule providing specifics on this aspect. Plus, the Sunshine Ordinance requires that there be, quote, each member of the public and, unquote, and, quote, each individual speaker, unquote, with regards to public testimony. The ordinance reads in section 6715 as follows in paragraph A, and I'm leaving out the part of the Board of Supervisors requirements. Every agenda for regular meetings shall provide an opportunity for members of the public to directly address a policy body of items of interest in to the public that are within the policy subject matter jurisdiction, provided that no action shall be taken on any item not appearing on the agenda unless the action is otherwise authorized by section 67.7E of this article. Paragraph B, every agenda for special meetings at which action is proposed to be taken on an item shall provide an opportunity for each member of the public to directly address the body concerning that item prior to action thereupon. C, a policy body may adopt reasonable regulations to ensure that the intent of subdivisions A and B are carried out, including but not limited to regulations limiting to total amount of time allocated for public testimony on particular issues and for each individual speaker. Each policy body shall adopt a rule providing that each person wishing to speak on an item before a body at regular or special meetings shall be permitted to be heard once for up to 3 minutes. Time limits shall be applied uniformly to members of the public wishing to testify. So I don't agree with the blanket labeling of just anonymous for all unnamed speakers without being able to distinguish between the multiple speakers, which we require for the minutes, and under public testimony rules of state and local laws here in the Sunshine Ordinance, part which I just read. One voice, one individual, one opportunity to speak on any single item at a time. In order to keep track, we need this distinction. So there has to be some delineation because many times one speaker does not want their person to be related or their statements to be related to somebody else's statement. Not all. So if you're naming everyone anonymous, then there's no distinction. And how are we to tell which anonymous is reacting to another anonymous's comments? Not all anonymous speakers speak for each other. We cannot discern by their name, or if we cannot discern by their name or some label, and as this particular anonymous stated as in the public comment, and in a email message to myself and to Vice Chair Yankee and to Administrator Leger, quote, should not distinguish by accent or voice, especially erroneously, unquote. Then by name, it must be. It's the only other way to distinguish between one speaker and another. So if we're going to keep claiming or notating that it's an anonymous speaker, there must be some way of distinguishing by some description, like a number or a letter. If a person doesn't want to be identified by their accent or voice, then they're free to enter their comments in writing. If there was no recording, then the accent and voice would truly be unidentifiable. But since these are recorded audio public meetings and we can hear voices, and as we all know, there's no guarantee of anonymity in public meetings or in public spaces, then one has to make a decision as to whether to reveal themselves in person by voice or visually. This can only go on so far within reason, and in order to be able to continue to run our meetings smoothly. So if the task force wants to overrule my position on this, then let's put it on the August agenda for discussion and possible action. Any other discussion on the matter? Okay, hearing none. Let's call roll.
We haven't got a motion.
Oh, we need a motion. Sorry. Is there a motion to approve the June minutes?
So moved by Member Highland.
Is there a
This
second?
is Member Wong. I'll second.
Moved by Member Highland, second by Member Wong. Any further commentary? Hearing none, please call roll.
Member Highland?
Aye.
Member Highland, aye. Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Did you say Member Stein?
Yes, I did.
Sorry, it cut out. Yeah, aye.
Aye, okay, great. Thank you. Member Forsley, is she present? Member Forsley absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the June 2nd, 2021 Task Force minutes has passed.
Okay, thank you. Please call next item.
Item number 4, file number 19145, hearing regarding request for reconsideration, complaint filed by Chris Kors against the Police Commission to the task force found that the Police Commission did not violate Administrative Code sections 67.5 and 67.21 for failing to respond to a public records request in a timely and complete manner. Shall I read the preamble, sir?
Yes.
Okay. April 7, 2021, the task force found that the Police Commission did not violate Administrative Code sections 67.21 and 67.5. On April 29, 2021, the petitioner emailed a request for reconsideration within the 30-day requirement. On May 25, 21, Chair Wolf requested that the matter be reviewed by the Compliance and Amendments Committee before going to the task force for reconsideration. On May 25, 2021, the Compliance and Amendments Committee found that based on the lack of new information, the committee recommends that the task force deny Chris Kors' request for reconsideration.
Okay. CAC Chair LaHood, would you like to make a presentation on this?
Yes, I can give a brief overview because I know not everyone was around for all of the, we've had several hearings back and forth on this. So this complaint originally was heard by the complaint committee back in September 2020. This was about Mr. Kors, what had a complaint that he had gone before the police commission in a closed session regarding his termination from the police department. He wanted a copy of the recording and a transcript of the hearing. And there was a portion of the hearing which was in closed session. There was a lot of back and forth over several meetings about whether a full recording of the meeting, including the closed session, existed. It was eventually determined that it existed. He was provided ultimately with the recording. However, Mr. Kors believes that he was not provided with a complete recording. There's a disagreement about this. The police department says that they have provided a complete recording. Mr. Kors disputes this. Nevertheless, as Ms. Leger stated, the task force found no violation, but then this was brought before Compliance and Amendments for possible reconsideration. Mr. Kors asserted that we did not and should have considered SB 1421, which covers off-duty conduct, and and relates to this issue because he was off duty at the time of the incident, which precipitated his termination hearing. He was off duty and he was involved in a car accident. He also says he still disputes the police commission. He still believes that there is that he has not received a complete recording. The police department, Sergeant Youngblood said that they did supply a complete reporting, and he says SB 1421 applies to off-duty officers, but that use of force doesn't apply in this instance because it was a traffic accident. We voted on this. It was a split decision. The committee recommended denying the request for reconsideration because there was a lack of new information provided. However, I did not vote with my committee members, so I don't know if member Neighbors or member Wong would like to make any additional comment on that. But I think that gives an overview of this case.
Thank you. Other members of the committee, if you would like to add, please do now.
Sure, just briefly, this was my first time hearing reconsideration of the decision. My understanding was that this decision should be made on the introduction of new information. And in my thinking, the argument for SB 1421 as a use of force wasn't satisfactory for that condition. It didn't meet the terms of new information. And so that was kind of my rationale behind that. And I don't know if member Wong wants to add anything.
Not necessary, but if you want to.
Yeah, nothing from me.
Okay, great. So we'll now move forward with our hearing portion. This is a hearing to whether to grant reconsideration. And the recommendation from the Compliance and Amendments Committee is to deny that. So why don't we hear from, is Mr. Kors here? You can unmute by pressing *6. Not hearing anything. Okay.
Hello?
Yes,
Hello?
are you here?
Yep, I'm here.
Okay. I'll give you an opportunity to address the full task force. I had requested that it be heard by CAC first in case there was a lengthy and extensive amount of discussion to try and narrow down the issues. Considering that it wasn't a unanimous vote, but though it was a majority vote, I'll give you 3 minutes to explain what new evidence that you think might convince the task force to allow reconsideration.
Is there any possibility I can get 4?
Okay, I'll give you 4 minutes.
I appreciate that. Thanks.
Mr. Kors, are you ready?
Yeah, I'm ready.
And be sure to give them a 30-second chime. Thank you.
Shall I give him a chime when his time is up?
No, chime at 30 seconds and then a second chime when time is up.
Okay. You ready, sir?
Yeah, go ahead.
Go right ahead.
All right. The Police Commission's most recent resolution determining not to release the records regarding file 19145 claims that they have an attorney-client privilege and that they refuse to waive in closed session deliberations.
The Brown Act does not, in fact, permit closed sessions for the purpose of attorney-client communications on its own, except regarding litigation. See Roberts v. City of Palmdale, 1993, 5 Cal 4363. Also see Open and Public 4 by the League of California Cities, page 36. Additionally, the new evidence found in Government Code Section 54956.9 states, in relevant part, nothing in this chapter shall be construed to prevent a legislative body of a local agency based on advice of its legal counsel from holding a closed session to confer with or receive advice from its legal counsel regarding pending litigation when discussion in open session concerning those matters would prejudice the position of the local agency in the litigation. For purposes of this chapter, all expressions of the lawyer-client privilege other than those provided in this section are hereby abrogated. That's important. This section is the exclusive expression of the lawyer-client privilege for purposes of conducting closed session meetings pursuant to this chapter. Please see the new evidence on page 490. This new evidence further supports that the requested documents must be released, and note that the Police Commission has not cited any section of the Brown Act for a proposition to have attorney-client privilege closed sessions outside of litigation matters. Instead, closed sessions have to be held under a specific exemption open to session permitted by the Brown Act. More importantly, the Commission did not publicly state the basis for the closed session as a litigation matter. Therefore, the records requested are disclosable. See the new evidence, Open and Public 5, page 42, as documented on page 491 of the evidence packet. Before holding a closed session, the pending litigation exception, the legislative body must publicly state the basis of the closed session by identifying one of the following three types of matters: existing litigation, anticipated exposure to litigation, or anticipated initiation of litigation. In this case, it was a personnel closed session citation that was used, not the litigation closed session. And because it was a personnel matter, not a litigation matter, Penal Code 832.7b, SB 1421, explicitly makes this recording publicly disclosable. In fact, the Sunshine Ordinance demands certain boilerplate language to be used to justify each closed session. The SOTF should examine the new evidence contained in the original agenda on page 492 of the evidence packet to realize that this was not an attorney-client privilege litigation closed session, but instead a personal matter closed session. Personal matters are not closed to protect not attorney-client privilege, but with the privacy of the employee. And I waived my privacy rights. As this task force knows, there is no deliberative process privilege in San Francisco, Admin Code 67.24H. This new evidence is documented on page 493 of the evidence packet. Some of the text was cut out due to the formatting issue, so I'll read it word for word. Neither the city nor any office employee or agent thereof may assert an exemption for withholding for any document or information based on a deliberative process. Exemption either as provided by California Public Records Act 6255 or any other provisions of law that does not prohibit disclosure. Additionally, the following is taken from page 7 of Open and Public 5, a guide to Ralph M. Brown Act, which is documented on page 493 and page 465 of the evidence packet. Again, some of the print was cut off, so I'll read it word for word. Generally, public officials should think of themselves as living in glass houses, and that they may only draw the curtains when it is in the public interest to preserve confidentiality. Closed sessions may be held only as specifically authorized by the provisions of the Brown Act itself. On top of that, members must also bear in mind that the Sunshine Ordinance Task Force requires a higher level of transparency than the California Public Records Act and the Brown Act. More reasons why the requested transparency must be provided. A few members of the SOTF incorrectly concluded that SB 1421, which requires all records related to certain kinds of police conduct be released, did not apply to off-duty conduct. Since the Police Commission's own interpretation, yes. Oh, shoot. Well, thank you for letting me talk for 4 minutes. That's it. I guess I'm done.
Okay. Ms. Leger, we did not hear the chime.
Really? Because I hit it.
Yeah, we didn't hear it. So I'm wondering if your mic, you were muted.
No, I'm not muted.
Okay. Can you just hit it so we can hear?
Did you hear it?
No.
Chair Wolf.
Yes.
Chair Wolf, it might be that the Microsoft Teams is interpreting that as background noise because it's not part of a flow of sound, and so I think it's canceling it out.
Okay. It may not be close enough to a microphone either.
Yes.
So That could be the same. Okay, well, then let's go back to a voice notice.
Hang on, I'm moving the chime closer to the, I want to see if this works because it's on my, excuse me, it's on my mouse pad.
Can't hear it.
Yeah.
Okay. All right, we'll have to figure out some other way to do it. I thought maybe it would work. Okay. All right. Members, discussion. Or a motion. Or questions for the petitioner for the reconsideration.
I would, Member Schmidt, I would say that if the law had changed in some way after the prior decision, if there's, say, a new statute, some kind of case law coming out of one of the courts, that would be a real good reason to maybe do a reconsideration. And it does sound like everything that I hear is that it's about what's in law, and I'm not hearing that there's anything that changed in the law.
I have a question then. We usually don't apply changes in the law after after the date of the case the case has been filed as a complaint, because the law, unless it specifically states that it applies retroactively, all our cases are heard based upon the time that the incident happened. So unless there's some other reasoning to apply a change in law now that would not have applied then, I'd like to hear it. Member LaHood.
Yes, this, I feel like this comes up occasionally, or it has come up recently because we've had a couple of requests for reconsideration. It seems that when in doubt, we have deferred to members of the public in terms of, or not deferred to members of the public, but that we interpret things generally in favor of members of the public when there's a question. One thing that's come up is a lot of people who bring complaints to the Sunshine Ordinance Task Force, especially those who are coming before the task force for the first time, are figuring this out as they're doing it. And, we want people to come prepared, but, the ordinance is complex, and the way things weave together with the California Public Records Act and the Brown Act. And I think often people don't understand everything they could present in defense of their argument until after we've made a decision. I'd like to know actually what my fellow task force members think about the idea that, if somebody makes a case and we make a decision, but then they come back with new information because they've done additional research. If it is truly information that was not considered the first time around, should we give them the opportunity again, or is that do people need to come to us with a fully formed argument the first time around, and that because they become more familiar with the ordinance and how our process works, should we be giving them a second chance because they know more by the time they've gone through the process, or is it just, sorry, you have to figure it out the first time around?
Let's clarify what the reconsideration is about. reconsideration is about bringing any new information that might change the outcome from the original order of determination.
Right.
It could have been subsequent information that had been gotten, and we only give a short period of time for reconsideration. It's only 30 days. Or if there was, usually that is the case, is there's subsequent information that was not part of the original record. It didn't arrive in time or what have you, but the task force went ahead and made a decision one way or another. So, and this applies for both parties. Reconsideration applies for both. So it's not so much a matter of process or necessarily understanding. If a person maybe wasn't sure whether to include a document or a record or not, and then decided not to include it, but then found out at the end of their hearing that that document would have made a difference, that is a perfect reason to do reconsideration and introduce new information that we had not seen yet or not known about yet that could alter the original outcome. If a reconsideration is granted, then we start at the point just before a motion is made. So we're back at a point of debate in considering discovery and discussion before a motion is made. Okay, so I don't know if that helps clarify things based upon what you had presented, Member Lloyd, but that is just how the reconsiderations are supposed to work.
Yeah, I mean, actually that does. Based on what you're saying, if a petitioner doesn't include information as part of their argument because they didn't realize that it would support their case, and then we make a decision, but they come back to us later with this information that was not formally presented, that they did not formally present, then that perhaps is something, if we think that it would influence the case, that is an opportunity to reconsider.
Right, correct. Right, Member Schmidt and then Member Padmanabhan.
Yes, just the idea that, and I don't think this applies in this case because I don't see that I don't see this happening, but the idea that someone can say, well, actually I had some other documents, so I want to come in and try those out. I'm not sure if I could see, unless the rule's written very clearly that should merit reconsideration. I'm not sure if I would vote for reconsideration in that situation. But again, that's not what I'm seeing here.
Member Padmanabhan.
I'm inclined to ask, I'm inclined to wonder about what Member LaHood has mentioned. And Chair Wolf, you mentioned an additional document, but additional research could actually form the basis of a document. So if the petitioner has done additional research to support his case that, and could change the way any individual task members could potentially vote, then I think we should look at it in greater detail.
Okay, thank you. So this is for either party. It's not just for the petitioner. It's for petitioner or the respondent. And I'll just, for everybody's edification, I'll just read from our complaint procedure for reconsideration. Within 30 days of a publication or issuance of order of determination, either the petitioner or the complainant or the respondent may petition the task force for reconsideration only if information exists that wasn't available at the time of the hearing. The petitioning party must present the new information and provide a written explanation of how the new information may change the task force's determination. The task force will accept no more than one request for reconsideration from each party for any specific complaint. That is the basis of the reconsideration. Everything in the rest of the procedure is just how it operates, when it's supposed to when the reconsideration is supposed to be heard, and so on and so forth. But the crux of how a reconsideration, in this case, if we were to analogize it with a court, this would be an appeal of a final of a original court decision. So, person has 30 days to file a reconsideration or quote unquote appeal of our order of determination, but they must bring new evidence that would change our minds from our original decision. And so that's the question before us today. Any other discussion? Is there a motion? Vice Chair Yankee.
Yeah, just briefly, I guess I'm kind of in a similar spot as Member Schmidt here. I just am not seeing and maybe someone else can point me to it, but I'm not seeing exactly what seems to be new here. I remember a lot of these types of discussions that we had the last time that we heard this case, and I'm not seeing some type of new document or overall new analysis that I don't think we considered last time when this vote was taken. So that's kind of, I guess, where I'm at on this one.
Thank you. Anybody else? Is there a motion? Motion would either.
May I ask Mr. Kors a question?
Sure.
Mr. Kors, can we hear you?
I don't know.
Yes.
Am I talking?
Yes, we can hear you. I have a question for you. So we received these information packets, and they're very lengthy, and it's trying to capture everything that you've presented to us. Can you we listened to everything that you read into the record in your initial 4-minute statement. Can you tell us succinctly, what are you presenting that is different that you did not present the first time around?
I'm presenting the evidence documented on page 499, where it specifically says off-duty conduct is part of, it should be included. This was a personnel closed session, not a litigation closed session. Therefore, it should be released. The commission initially violated the law by saying that the records did not exist, and unless the commission can cite a specific CPRA exemption for withholding the recording, and the records must be disclosed. Pages 511 and 512. These records are a subset of personnel records, and I have a recording of, if you want to hear the actual, statements by the respondent. These are personnel records, and they should be released. The evidence on 469, pages 514 and 515, email sent between Angela Wilhelm and Benjamin Houston, the human resources manager, basically supports this stance. To say that this was not a use of force. Well, I think, when an object crushes someone's skull, traumatic brain bleed, broken jaw, I think that's a use of force. I mean, great bodily injury was sustained by an object slamming into somebody. And I don't see any reason why intent has anything to do with that. A use of force is a use of force. Sure.
Just to be clear, you are presenting this as new information that you did not present in your original complaint. Is that correct?
Correct. All this is new. I mean, I didn't have time to. Yeah, this is all new.
Thank you.
It would have been helpful to have it would have been helpful to have a kind of a written narrative from you, Mr. Kors, explaining all this. I don't see it in the record.
Oh, asshole.
Excuse me?
I believe I did send it. I believe I did send it in the record. But I mean, hey, maybe I'll have to double check, but I feel fairly certain I sent you all this in the record.
Okay, thank you.
Yeah. So please double check. And I don't know who made that comment. That was not me, by the way. So
Okay.
Just want to let you know. Yeah.
Thank you. Could everybody on the phone please mute yourself? Won't tolerate any interruptions like that. All right. If you're not going to do it, then I'm going to mute you. Okay. We have members Neighbors and then member Schmidt.
Thank you. I think that the request and the spirit behind Chris Kors wanting this information is very compelling, and yet if you're, the definition that you gave us seems to me to be very clear about information existing, and that's not even the same thing as analysis or research. It is evidence that exists, right? And this information existed. 1421 existed prior to this, and the other piece of it being that if it turns on the definition of use of force as including a traffic accident, I'm concerned about that interpretation also. But even downside, whether or not we say use of force, that force does include a traffic accident, to me, it still doesn't meet the minimum. We still were aware of this of SB 1421. We were still aware of those details about what the hearing entailed and what it didn't. And to me, it's not the same as bringing in a new piece of paper or missed something that wasn't in the first case. It was stuff that we already had access to.
Member Schmidt, I was going to say something, but Member Neighbors said it much more eloquently, and so I will just approve what she said. Thank you.
Bruce, I think you're muted.
Okay, so we're running close to about 30 minutes on this now. I want to try to see if we're coming close to a motion or if you need more information at this point.
This is Sergeant Youngblood from the Police Commission. May I say one thing?
Yes, well, I'll allow it.
In regards to a use of force by an off-duty officer.
Yeah. Oh, hold on, Sergeant Youngblood. We're not going to re-adjudicate the case. Okay. I'm not going to re-adjudicate it or allow it. What we're doing here is just determining whether there is enough evidence, new evidence that is being brought by the person asking for the reconsideration. If it's new or not, and new enough, whether it would change the outcome. That's all we're doing here today. If we grant the reconsideration, then we'll be scheduled for another full hearing, then we'll have an opportunity to break down all the merits. So, with that, if you have something to add, go ahead.
Then I guess I'm good.
Okay, thank you. Okay, members, is there a motion? Member Schmidt, go ahead.
Well, yeah, as to what I think Sergeant Youngblood wished to say, I think, there is one question, which is there something new here? And then number two is, if there is something new, does it matter? And so I think he would be saying that on that other question, whatever is submitted as new, is it material to changing the original decision? So I'm not sure if what he would tell us would be completely irrelevant to reconsideration.
I didn't stop him from not saying anything. I just wanted to let him know what our process is and what we're making a decision on today. Will we allow the reconsideration or not based upon the new information that was presented by the petitioner party as to whether we, the Sunshine Ordinance Task Force, agrees that this new information may change the outcome of our original decision? It has to be new information, not a rehashing of old information. I mean, it's a high bar, just like any, an appeal would be. So, I mean, it's a very, simple. It's almost, just simple black and white. Vice Chair Yankee.
I guess for the reasons that member neighbors so eloquently stated, I will move to not reconsider this case.
Okay, so is a motion to deny the reconsideration. Is there a second?
This is member neighbors. I'll second.
Okay, moved by Vice Chair Yankee, second by member neighbors. Is there any further debate on the motion to deny the reconsideration? Okay, let's open up public comment. In public comment, to be pertinent to whether there was new information or not on the old merits of the case. This is only for reconsideration on whether the new information presented. Okay.
Yeah, could I speak, please?
Who's that?
Anonymous, could I speak, please?
Yeah.
Yeah, so I had a question about the new information. So it seems to be a conflict that the person, Chris Kors, was saying he did provide new information. And then the people representing this hearing, some of the people that I've heard from are saying that he hasn't provided new information. I just wanted to ask, has everyone on this hearing read through and through the information, all the information that he provided in this last instance? So basically what I'm saying is if all the information the new information that he says he has provided is actually new and it hasn't been 100% read through by everyone in this hearing, then how would you deny this man the right to say that there isn't new information? And so I just wanted to bring that up because I think there should be transparency. And in this case, it just seems like there's something's missing. And I think transparency is very important for the city of San Francisco. And this gentleman seems to really be compassionate about not being able to have that transparency. And it's obviously affecting his livelihood. There's other people on board that seem not to want to be fully transparent or to guard some type of information. And therefore, I just wanted to make sure that the information that was served by Chris in this last hearing was actually 100% read through, and that everyone knows there isn't any new information in this before they were to say there's no new information. Thank you very much.
Hello, can I?
Do we have a speaker who wants to make public comment?
Sullivan?
Yes, please.
Mr. Sullivan, are you ready to speak?
Sure.
Go ahead, sir.
Okay, so the procedures also say if information exists that was not available at the time of the hearing. So if the information exists, it doesn't exactly say when it has to exist. It was not available at the time of the hearing for people to consider, is what I would read that into. I also want to point out that the reconsideration procedures say information or new information, not new documents or records or new evidence. But it has to be, you know, the person has to explain why it may change the soft determination. But when you guys, I think you guys should stick with information or new information and not say new documents or records or new evidence. And that's the end of my comment. Thank you for your.
May I speak?
Just a moment.
Have you heard my request, or am I muted, or what?
You are after the person who just spoke. So we have a woman, another speaker.
May I begin?
Yes, you may. Are you also anonymous?
Sure.
Okay. Go ahead.
I am a 44-year resident of San Francisco, and one of the things I like and respect about our beautiful city is the efforts that are made via task forces like yourselves to be transparent in all levels of city government. And this gentleman, Mr. Coors, is obviously seeking redress about something that he feels strongly about enough to have done a lot of research on it. And I think, as one of the previous speakers said, hopefully every one of the task force members, every one of you folks, has thoroughly read his latest presentation. And then do you run something like this by a city attorney to make sure that everything is legally accurate? Because I think he deserves a second go-round at this. This is very important that a city agency is possibly not providing information that Mr. Coors is entitled to. And it's very distressing to hear that as I listen to this meeting. And I do hope you vote to reconsider his plea and go back and check all the documentation he has given you this time around, talk to the city attorney, and then you can render a full and fair decision. I thank you.
We have a new speaker.
Is that me?
Mr. Warfield?
Yeah. Let me know when.
Go ahead, sir.
Thank you. Peter Warfield, Executive Director, Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California 94117-0544. We're not a party to this, and we're not familiar with this. And what I can say is that I appreciate the discussion. I appreciate the sentiments of the folks who brought up the issue of new awareness as well as new documents. So the first thing I would say is that you seem to routinely suspend rules that you have in various at various times when it's, for whatever reason, convenience, timeliness, and so on the top of your agenda for that matter. The second thing is that there is, and especially as some of the folks noted, for people who are not lawyers or extremely familiar with sunshine law and procedure and so on and so forth, courts were mentioned, and just as something to think about, courts will sometimes, as I understand it, take a statute of limitations and not apply it necessarily to the action that caused the harm, but rather to start the clock from the time that the harm was discovered. So if somebody is spraying near where I live and I don't notice anything until 10 years later when I'm getting cancer or my family is getting cancer, it's generally understood that there might not have been any way for somebody really to understand what the impact was of the offending actions, in this case of spraying nearby, until there was some other event that happened, which basically means an awareness happened. I do think that that does happen sometimes, and that is something that should be considered.
30
In
seconds.
addition, I've often thought that there may be instances where the delay of an agency in providing information, somebody might want to make the 30 days and may think there is something additional that could be found, or even knows something. If the agency blocks or delays that provision of that information, that might also cause the new information to exceed the 30 days, and so on and so forth. In any case, I think there should be a generous consideration. Thank you.
May I speak?
Hi. Oh. I was wondering, can I speak?
Anonymous?
Hi,
Which
this
of
is Karina. Oh, sorry. Go ahead.
No, go ahead. You're more than welcome to go ahead.
Oh, sorry. I'm Karina Wong. I just feel that these are public records, and by law, they should be disclosed. Thank you.
I didn't hear what you said, ma'am. What?
I said Karina Wong, and I feel that these are public records, and by law, they must be disclosed. Thank you.
May I speak?
Hang on. You ready, sir?
I am.
Go ahead.
Thank you. I'll call myself anonymous number 3 since there's 2 other anonymouses, and I'll try to use that consistently throughout. So it seems like a large part of the public correspondence, written public correspondence I said, has actually been cited by the petitioner in their opening statement, so I'm not going to repeat any of that. But I will say that your procedure says only if information exists that was not available at the time of the hearing. And so if any of you believe that maybe some of the information about their citations to being attorney-client privileged, even though I don't think it can be, or about how SB 1421 might not apply, if you don't think that was available to you, the task force, because I don't think it says available to whom. Is it available to the petitioner or available to each member of the task force? If any of you think that any of that information wasn't available to you, I would urge you to vote for a reconsideration. Thank you very much.
Any other public comment?
Yes, anonymous. Can you hear me? Hello?
Yes, we can hear you, sir. You want to speak?
Yes,
Do we have
hello.
an anonymous speaker?
Yes, I'm an anonymous speaker.
All right, sir.
Yes, I fully concur with the lady that sometime before made some comments about Mr. Coors having major concerns. First of all, they get 3 or 4 minutes to explain their concerns. Isn't that much time, but I know you have busy agendas. But I read through that packet. To me, there was a whole lot of new concerns that are really relating to the need for transparency. And in that light, I'd like to play a little clip that was provided relevant to transparency and what can happen without transparency. Just a moment.
The doctor and the doctor stayed left with your client. Pardon me? The doctor was in what car? In the car with my client. He was a friend. The doctor and his brother were friends of his. They were in the party. And did the doctor get out and tend to overhead? The doctor, I think, yes. The answer is he was there and he went to the injured. That's what I know of the case. I also know 911 was called and the police came and paramedics came. Did the doctor leave with your client? He did not leave. He stayed there and was interviewed by the police department.
But the incident report says that all the occupants left the scene prior to the police officers arriving.
That's not accurate. That is not accurate. I don't know where you got that actually.
The incident report?
They're saying they didn't, these people were not there, the brother wasn't there, and the doctor, the passenger wasn't there. That's not accurate. When the police arrived, they both were interviewed. In fact, they talked to the brother, and they wanted to know where he was.
Well, that's one of the reasons why I think we really need all the transparency that we can get. Even right now, the police commission doesn't even want to release the tapes to the SOFT commission. I don't understand that. What are people trying to hide? And I read all of those things that were put into the news or the packets. To me, there's a lot of new information there, not only on the things that Mr. Coors got a chance to mention today, but also on going through, what is it, the Brown regulations. I don't know the layman, but anyway, we really need to get out of this, to get the transparency, and I fully support having a lawyer, someone read through what Mr. Coors had to say in that packet, review it, approve it, and let the people know. The other thing, everyone that's on SOTF should have read that. Listening to some of the people, I don't think that's happened. Anyway, just my comments. Thank you very much. Bye.
Okay.
Hello. Hello.
Hello, can we help you?
Yes, my name is Naveed Filsuf. After listening, I'm strongly in support of the new evidence provided by Mr. Coors to be reviewed before any new vote has been made. It looks like the new evidence is incredibly detailed. A lot of time was spent on it, and I think that at the very least, it should be reviewed so that it can have due process.
Excuse me, sir?
Can you hear me?
Yeah, I can hear you. You said your name and I didn't hear it.
So my name is Naveed Filsuf, and I think in light of how detailed Mr. Coors was, I think the evidence he provided on 6/27 should be reviewed before the vote before the next vote is taken. Given how much time he put into it, I think we owe it to him to give him full transparency on this. Is there anything else I can say? Did you hear that?
Yep, we heard it. Thank
Okay.
you, sir.
Thank you.
Any other public comment? Last call. Okay, public comment is closed. Okay, members, any last thoughts? Are we ready for a vote? Okay, please call roll.
Just a moment. Member Yankee?
Aye.
Member Yankee, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Padmanabhan?
No.
Member Stein?
Nay.
Member Forsley? Absent. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
No.
Member LaHood, no. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
No.
Chair Wolf, no. The vote failed because we had, we have 5 yes and 4 no.
Okay. Is there any other motions?
I'd like to make a motion to reconsider this case before the full task force.
Okay, moved by member LaHood to allow reconsideration. Is there a second?
I will second that.
Who's speaking?
Member Padmanabhan.
Okay. Moved by member LaHood, second by member Padmanabhan. Any discussion? Okay, let's open it for public comment.
Hang on a second, Bruce. You are opening this matter up, Lila, for reconsideration.
Yeah, it's just the
I made a new motion.
Yeah, it's the other way around. This is to allow reconsideration. Okay, ready for public comment, Ms. Leger?
Just a second. Okay, do we have a speaker?
Sure, this is anonymous number 3.
You ready, sir?
I am.
Go ahead.
Thank you very much. I strongly urge you to vote in favor of a reconsideration. I think that this case, whether it's intended to be or not, can have a precedent that would harm disclosure of police misconduct files. And if a police claims that they hit someone with a car and it was just an accident and is off duty, and that doesn't count as SB 1421, I think that's very dangerous. And I think that whether or not that's how you intend it to be. And so I think that I will, again, my public correspondence, it seems like, has been read almost word for word by the petitioner into the record, but at least the first half of it. So I would strongly urge you to vote in favor of a reconsideration and actually now consider then these provisions of the Brown Act, whether they properly cited it, whether they properly put the agenda, and now whether they can claim any kind of exemption on that basis. And maybe do additional, maybe consult your DCAs about what exactly is part of SB 1421 and not maybe based on some case law. Thank you very much.
Next speaker. Last call for public comment.
Hello, this is.
Yes, please.
Hello, this is Naveed Filsuf again.
Hello.
I just want to make it
Okay, hold
clear.
on, Mr. Naveed. You have to wait your turn, and the administrator, the clerk, will let you know when it's time for you to speak. Let's make sure, because we got a number of people that want to speak here. Let's keep them in order. Appreciate it. Thank you. Ms. Lachey?
I believe Mr. Warfield was the next commenter.
Yes, please.
Go ahead, sir.
This is Peter Warfield. Thank you for the motion, and we certainly are in favor. Basically, if in doubt, if there's any doubt in anybody's mind, I think there should be, as I said, a generous understanding and interpretation. I would certainly agree with what Anonymous has said. And again, a generous and an ample appreciation. I would certainly favor, if anybody is in doubt, having a reconsideration in the interests of fairness, of justice, rather than a closure and a non-consideration. So supporting the motion. Thank you.
I'd like to speak.
Hold on. We have Mr. Naveed first, and then you.
Thank you.
Hello, this is Naveed Filsu. Thank you, sir. In the interest of full disclosure, in the interest of fairness, I strongly urge you to support a reconsideration. There was new evidence provided on June 27th by Mr. Coors. I think we owe it to him, to our system, to give him his fair shot. And I would like for a reconsideration to happen so that he can have his due process. Thank you.
Anonymous here. Hello.
Ms. Leger.
I hear him.
Thank you.
There's a speaker before this last one that goes first.
I'd like to speak. I think that was me.
Correct. Wait for,
Sullivan's on too.
yes, wait for Mr. Leger to let you know when the clock has been reset. Thank you.
Thank you. Can I go?
Not yet.
Okay.
I'm waiting for the gentleman who is anonymous number 4.
No, Ms. Leger, it was the person who was just speaking now. That goes before that.
The woman?
Yes.
All right. How do you want to be identified, ma'am? As anonymous?
Sure. It seems like everybody's doing that. So yeah.
Go ahead.
Okay, thank you. I'm just confused on what is happening here. I guess the argument is that if a person is in an accident, that's an intentional act, and that becomes a use of force by a police officer. But that seems kind of illogical to me in the sense that you're saying that every time a police person is in a car accident, that they have to report that out, and it's almost like they're intentional. It seems to me that a use of force is something intentional, so that Mr. Coors was then intentionally running into that other person. That's pretty bad if he's saying he did that. So I guess you can reconsider, but it seems to me, I don't know why Mr. Coors would admit to intentionally hitting someone. Thank you.
Anonymous here.
Just a moment, sir.
Thank you.
Go ahead, sir.
Yes, in response to the last lady's comments, I don't think that's at all what Mr. Coors was saying, that he intentionally ran into anybody. He was talking about the interpretation of the law that the task force, or some members on the task force, had put in place. And he was discussing that. But other than that, I fully support that we reconsider. We absolutely need transparency. And I don't understand why the police commission or the respondent is so demanding and not releasing a lot of the information. I don't understand what they're trying to hide or cover. So I think we need to proceed with transparency, and everyone should absolutely read that memo that he sent on, I believe it was 6/27, as the last caller stated. That's my comments. Thank you very much.
Last call for public comment.
Sullivan,
Can I speak?
Sullivan,
Okay, wait for the clock to be reset.
You ready, sir?
are you talking to me,
Yes.
Sullivan?
Yes.
Okay.
Go
So,
ahead.
all right, California Constitution, Article 1, Declaration of Rights, Section 3(2). A statute, court rule, or other authority, including those in effect on the effective date of this subdivision, shall be broadly construed if it furthers the people's rights of access, and narrowly construed if it limits the rights of access. Top of your complaint procedures. Consistent with the language and spirit of the Sunshine Ordinance, to provide the most open government possible. See City Administrative Code, Section 67.1. All inferences and evidence shall be viewed in the light most favorable to the petitioner. I strongly think that you should see all evidence in light most favorable to the petitioner. Thank you for your time.
Okay, I'm going to close public comment. We're running
Well,
way
can I
over.
speak? I've been waiting.
Haven't heard your name come up, sir. I'll allow this last one, and then I'm closing public comment.
I'll start when you're ready.
Go ahead, sir.
Thank you. First off, I just wanted to applaud those that had doubt and were up to reconsider. I believe that there's definitely doubt within the constituents on this board. And I think that being said, I also feel that there's room to go over more of the information. I don't believe whether it be a time constraint or not, or resources, everyone has had the time to thoroughly even understand whether there is new information within the thorough amount and detailed information that Christopher Course has presented. Therefore, all these things being said, I think it would be to the benefit of the city of San Francisco that this was reconsidered, especially since the esteemed board members here, or this group of people here, that there is doubt within this group. Therefore, I know based on that there is room to look into this further, because I do respect the intelligence of the people within this committee. So that being said, I urge that you do reconsider. Thank you very much.
Okay, public comment is closed. Members, are any further debate or comment? Hearing none, are we ready for a vote?
Okay.
Please call the roll.
Just a second. Member LaHood.
Aye.
Member LaHood, aye. Member Padmanabhan.
Aye.
Member Padmanabhan, aye. Member Neighbors.
Aye.
Member Neighbors, aye. Member Stein.
Aye.
Member Stein, aye. Member Forsley, absent. Member Schmidt.
Nay.
Member Schmidt, no. Member Wong.
Nay.
Member Wong, no. Member Yankee.
No.
Member Yankee, no. Member Highland.
No.
Member Highland, no. Chair Wolf.
Aye.
Chair Wolf, aye. It's 5-4 in favor.
It fails.
Yep, fails.
Okay, so I'm sorry, Mr. Kors, we've gone round and round on this. I would suggest your next stop possibly would be a court. The task force, I believe, has done its due diligence to provide the kind of administrative process, local process, and that is what's required generally by court. And I don't know, there's not much else that we can do at this point. So I appreciate your time. I appreciate everybody else's time and your comments, but we must move on now with our meeting. We passed the 5 o'clock hour, and our next item is public comment.
Are we public comment?
Yes, yes.
Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Are you asking for public comment?
Yes, that was the item called. Our next item on the agenda.
Well, yes, please.
This is general public comment.
And if you could cue anonymous number 3 after Mr. Warfield, please.
Are you ready, Mr. Warfield?
Yes,
Go ahead.
thank you. Peter Warfield here, Executive Director, Library Users Association. Library Users 2004 at yahoo.com and P.O. Box 170544, San Francisco, California 94117-0544. First of all, I wanted to say that we appreciate the win, if you like, at the June 2nd meeting concerning our complaint against the Library Commission for the way that it was running its meetings in such a way that it was preventing public comment. What I'd like to ask for, and I don't think I've ever asked for this before in all the years and all the complaints that we have brought, that it be referred and taken up by one of your committees. The likely candidates are one or both of the Compliance Committee and the Education Committee. And the reason is that there were quite a number of reasons that the Library Commission's actions with regard to running the meeting violated the law. You found at least 2, and but there were a number of quite a number that weren't specifically cited. So I think that there was a lack of real clarity as to what can be expected with respect to a properly running remote meeting. And I think that that's something that would be very worthwhile to get into and to really delineate clearly as to what's expected. I can tell you that subsequent to your meeting June 2nd and the library's attendance to defend the Library Commission, there was absolutely no change since the 2 changes that they made in March when there was a hearing imminent. They had the same incorrect and misleading instructions on the agenda, as an example. And in fact, that Thursday's meeting, there was somebody who kept swatting me down when I pressed star 3 to indicate I wanted to make public comment. So I think there's a whole question of how is it run, how is the instructions given, how is it implemented, and so on, that I think would be very worthwhile, not just for the Library Commission to ensure that they're following proper procedures, but also for everybody else and in the future. I'd also like to say I'm disappointed that Kevin Frazier's resignation is not mentioned anywhere on the agenda. And I think the chair did the right thing and notified supervisors about the resignation, but I think that that should be on the agenda at the end of the where the commentary is taken up. Thank you.
Do we have another speaker?
Yes, this is anonymous number 3, please.
Go ahead.
Thank you very much. Good evening, Task Force. This is Anonymous. I don't tell you during hearings about what impact my records requests have because on principle, and according to the CPRA and courts which have considered the constitutional right to access public records, it doesn't matter. Every person for any or no reason has a right to public records. That's the law. That right is limited solely by statutory exemptions and sheer volume of records. It's not limited by subjective importance of those records and importance to whom. So I'll give you some examples from my cases. You ordered disclosed an email thread of an SFPD sergeant doing forensics on a journalist's computer in an FBI task force. What you may not know is that the other portion of that thread is cited by the Reporters Committee for Freedom of the Press in a suit against the DOJ. You found the police commission failed to properly redact and key its emails. What I did not tell you is that those emails contained the non-Brown Act meeting conversations with commissioners discussing how to politically protect the chief of police for that raid on a journalist. You ordered production of SFPD's command staff text messages with their sender and recipient metadata. What I didn't tell you is that my follow-up to that request is what proved that Mayor Breed personally directs Chief Scott to sweep homeless people when they are within her personal proximity. And I certainly could not know, after those texts went viral and were widely reported, a new anonymous requester who discovered those texts would go on to use those tactics to find as many abuses of homeless people in city emails as possible and publish them, including on Jeff Kazitsky, who has apparently recently resigned. You haven't yet heard my complaints about Harlan Kelly's texts or the Public Utilities Commission. The contents of those texts that I found last summer via request are cited in the federal charges against him, but I had them produced first, months before those charges. And I immediately appealed to you and to Herrera when I found out, via the native electronic files, that Kelly was hiding conversations with Walter Wong, a guilty pled city contractor. I was right in the end. Herrera and PUC were forced to disclose the remaining unlawfully withheld messages half a year after my appeal. Indeed, forcing the city to not print and scan is what allowed me to figure this out. That is the incredible power of random sampling records requests, exact electronic copies, metadata, and of appealing every single abuse of withholding, which I will continue to do. But I didn't know any of these effects would occur. They're second, third order effects, and neither did SOTF. Yet you straightforwardly enforced the letter of law in each case, which is your duty, not to judge or gatekeep the right of public access, and I hope you continue to do it. Thank you very much.
Hello.
Hello?
I would like to make public comment. Can you hear me?
Just a moment. Go ahead, sir.
Thank you very much. I have my own timer, so I don't need to be interrupted. My name is James Chavey. I made a complaint consisting of 5 letters and involving violation of 3 sections of the ordinance that are intended to guarantee that certain information is available on the internet. I sent my initial letter describing the violations on February 4th, 2020. On March 10, 2020, I sent a follow-up letter stating that I had received no acknowledgement of the receipt of my complaint and requesting such an acknowledgement. I received nothing. A year later, in February 2021, my complaint was assigned to a committee hearing, and the deadline to submit a reply or additional material was February 18, 2021. A notice informing me of that fact was sent by regular mail, postmarked February 19, the following day. I received that notice in due course on February 22nd. That same day, I sent an email response, which I didn't want to do, pointing out this gross negligence, which was a violation of due process and highly prejudicial to the complainant. The hearing before the Compliance and Amendments Committee was the following day, February 23rd. I sent another letter on March 10, 2021 to address the preposterous defenses offered by the respondent department. I received notice on May 17 that my attendance was required at a task force meeting on June 2nd. I sent another letter on May 27, 2021, stating that there was no authority for such a requirement and addressing additional issues with my complaint. I asked Mr. Warfield to convey to the task force that since I had received no reply to my May 27 letter, I assumed that a lack of response was an admission that there was no such requirement. At the suggestion of Mr. Warfield, I listened to the recording of the meeting and was shocked to hear Mr. Wolf state that I was challenging the task force, which he had invented out of whole cloth. On the agenda of the June 2nd meeting, I noticed that my complaint had been transformed into a records request complaint, presumably so that the respondent department could claim I had received my documents, even though no documents were at issue. This clearly constitutes a pattern and practice of defending sunshine violators against the complainants. You have to understand that these sunshine violators are involved in thousands of dollars in graft and millions of dollars in embezzlement, and concealment of those crimes is harmful to the public interest. Now, there are a lot of things you can do. I know what you're saying to yourselves. What can we do? We don't read the complaints. What can we do? Bruce Wolf is an idiot. Well, in fact, there's a lot of things you can do. You can be proactive in addressing problems of sunshine in this city.
Next speaker.
Sullivan.
Anonymous.
Mr. Sullivan, are you ready?
Yep.
Go ahead, sir.
First of all, I think the Compliance and Amendment Committee made a good motion to get input from council on my reconsideration at the last hearing. Any entity or other body that is in question before the task force should be considered in relationship to the government, public officials, public money, and the entity's goal. Not doing so ignores the elephant. You should not silo the entity. Requiring a department to be named in the complaint misses the point of jurisdiction. Question of public access is not protecting one entity over another. It is about government activity through an entity for government purpose, regardless of whether they are shared with the entity. Government is to be open for all people. Changing subject. I want to point out to the task force that the mayor's proclamations and suspensions of various parts of the Sunshine Ordinance are still in effect to my knowledge. I noticed the task force is still considering findings on complaints on those suspended parts of the ordinance. In my opinion, they should be using the Brown Act or California Public Record Act, where the incidents of the complaints fall within the period of the suspension. Unless there is some memo or order I'm not aware of, there seems to be an inconsistency as to the task force implementation of public access laws that should be used and what city officials are using during this time of the declared emergency. I looked at some of the past agendas and there are complaints that would be affected. I'm certain this will affect more complaints consideration going forward. I could say more, but I'm just going to say thank you for your time.
Do we have another speaker?
Anonymous.
Okay. Go ahead.
I'm very concerned with some dangerous precedents that have been set by this unconventional way of conducting meetings. There are people I'm listening to on the phone that I do not understand, that I think I would understand if I was in the meeting, in the room, in City Hall, where I've attended many, many task force hearings over the years. There are people who are speaking that I think you have to be a clairvoyant to understand what they're saying over the telephone. It's a severe degradation of the functionality, if not legality, of these meetings. I do honor the people on the task force who are volunteering their precious time to these meetings. One of the most dangerous precedents that we're living with, that I'm very fearful will continue, is the cutting off of the telephone by the administrator, who prior to December, and for at least two previous administrators, and probably even further, the administrator of the task force would answer the phone at her office phone. She stopped doing that in December, and has severely inhibited, if not denied, public access to her communication with regard to the business of this task force. She has admitted in meetings of this group that she works 40 hours a week for the task force. Other records would reveal also that she gets paid $140,000 a year. I don't think we're getting our money's worth. She will not answer the telephone. She is denying the right we all have to anonymity by pretending that if you leave a message, she'll call you back. Well, that would deny my anonymity. The Sunshine Ordinance gives me the right to complain anonymously. The administrator is denying me that right. This is a violation of the Sunshine Ordinance, not to mention due process law in California and in this nation we live in. So I urge that the administrator, as I've done this in other public comments, to set aside at least 2 hours a week when she's publicly announcing that she's available to answer the telephone to communicate with complainants and the public. That has not worked since December, and I feel outraged that I'm being denied the ability to communicate with the task force in its very important business. There are other complaints I've aired with regard to the administrator, but I'm very, very concerned that when and if we ever get out of this COVID crisis, we are going to be assuming this is the new norm. It's a severe degradation, and I wish this to be stopped and reversed. Good luck. You do good work, very important work here, but a lot of it is being denied to the public because inefficiencies in the system. I thank you for your help.
Do we have further public comment?
Last call for public comment. Okay, hearing none, public comment is closed. Let's call the next item, please.
Item number 6, file number 19143, complaint filed by Anonymous against Sheriff Paul Miyamoto, James Wilson, and the Sheriff's Department for allegedly violating Administrative Code Section 6724, 25, and 27 by failing to respond to an immediate disclosure request in a timely and/or complete manner. I'll read the preamble. On January 28, 2021, the Compliance and Amendments Committee determined that the task force has jurisdiction. On April 20th, 2021, the Complaint Committee moved to find that the requested records are public and referred the matter to the task force with the recommendation to combine files 19143 and 20009.
Okay. All right, so this is a regular hearing. We are going to hear from both parties first, and we'll have a period of time for discovery and questions and answers. We'll hear some rebuttals, and we'll have some deliberation to develop a motion. And so we shall begin. Ms. Leger, are you ready?
Yes, I am.
Okay, great.
5 minutes.
Is the petitioner Anonymous here?
Yes. Am I here to discuss just this one or both combined?
Well, they are not combined as of the moment. So we're going to be hearing them independently. There doesn't look like, oh, it does, hold on. Let me just ask Compliance and Amendments Chair, Member LaHood, is there anything you wanted to present here? And I know there is a recommendation to combine these files.
I'm sorry, we just found jurisdiction, but I think the Complaints Committee has more to say about these items.
It is Complaint Committee, yeah. I'm sorry, yes. Complaint Chair Schmidt.
Well, I think that we should certainly have them in the same consecutive because they involve the same parties. But I don't know if there's any real reason to combine them. They do involve somewhat different requests. The both of the cases, I think the main thing I would mention is that the sheriff's department seems to have been sort of slow on the uptake here, but they did acknowledge at our hearing that they're trying to sort of, I don't know if you'd say make amends, but they're trying to improve their process. And so I do think they concede that there were problems in their responses here.
Okay, so let me ask, it says here that there was a recommendation from the complaint committee as part of your motion to refer the matter to task force to combine these two items. Are you now saying you're saying now that that's not your recommendation?
I don't know if I recall specifically. Again, this is Member Schmidt, and I'm not sure if combine would mean that somehow they become the same case number. Though I should allow the other members of the committee to speak to these things also.
Okay. Anybody else from the committee have anything to present? Nope. No explanation on this? All right.
This is Member Wong. I'm not speaking specifically to what the complaint committee found, but I was a little bit confused because it says that we, on the Compliance and Amendments Committee, found that we had jurisdiction on January 28th, but it looks like we didn't have a meeting that day. I think we had a meeting on the 26th, and I don't actually see either of these files on that agenda. Can someone maybe double check that or double check me on that?
One moment.
That would seem to be more what one would expect here is
Complaints and amendments met on the 28th. On the 26th. January 26th.
May the petitioner provide some information here?
One moment. Just give me a moment for a second. Yes. Go ahead, petitioner anonymous.
I believe this is one of those 45-day issues. I believe this was determined for jurisdiction maybe January 28, 2020, and not 2021. That might be the confusion, but I can't be certain.
Yes, I think that's what happened here, and that's why compliance and amendments is noted, but that in our notes for the cases,
Yeah. Okay,
so we didn't actually have a hearing on the substance of the cases.
This is Member Wong. Yeah, I'm seeing that now in the agenda for January 28, 2020.
Right. Okay, I see that too. Okay. So, but the second one, 20009, was not heard at that meeting, I don't believe.
Again, if the petitioner may, I can read out your motions. I have them in front of me. So.
Yeah, one moment. It's fine. It's just a. Hold on. Is it just a motion for the for finding jurisdiction? Because I'm not understanding why it was heard for jurisdiction in one committee and then it somehow it ended up in another committee. This was not made aware to me.
This was back in 2020. It looks like there's a typo on the agenda. It says January 28th, 2021. It should be January 28th, 2020.
Yeah, but then it says on April 20th, 2021, the complaint committee moved to find the records that are public. So is that for the other one? 200?
No, we found jurisdiction for because of the 45-day rule.
You only found jurisdiction for the first one, not for the second one.
Sorry.
Member Schmidt, 20009, did that come before your committee?
Yeah, both of these did on the same day. And, again, it seems like they should be combined for hearing purposes. I'm fine if we wrap them together and we just hear it all at once, but I don't think that's what what we were thinking the word combined necessarily requires.
Okay, because we have a provision to allow combining of two cases if it involves the same petitioner with the same respondent in order to, if the merits are close enough together, so that we don't have to have a duplicative hearing one right after the other. So we combine them together, and we would if there and the respondent can claim that there's a difference between them if we choose during the discussion about combining. Okay, because the motion to combine is public comments open to everyone, including parties for that. So that's what this is. That's what we're trying to ascertain here.
Okay. So it sounds like you're saying that there'd have to be a motion to combine here. And right. Okay, and that's not something I necessarily need to go into as a motion to combine. Let's just hear them one after the other.
Okay, so here's so we have an issue here. One, that item 19143 has been heard twice by committee for jurisdiction. Okay, that's the first thing I want to notate. Second thing is 20009 was heard once by the complaint committee on April 20th. Okay, and the motion on April 20th, you heard both these. You heard 19143 first, and then you heard 20009 second. And in the second one, the motion was moved by Member Stein, second by Member Forsley, to find that the task force's jurisdiction, find the requested records are public, and to refer the matter to the task force for hearing, with the recommendation to combine the files. Okay, so that's where we're at right now. Okay, so if you have any information, or any Member Stein has any information, because Member Forsley's not here, to help the rest of the task force out as to whether this should be combined or not, then let's deal with that first, so we can move this forward.
I don't think I have anything to add. This is Member Stein.
Okay. Okay. So, all right. So we have so then let's proceed with them to be independent. I'm not hearing any compelling information to combine them at this time. I read through these. I would take them independently or combined, either way. If somebody wants to make a motion to combine them, happy to take it. Otherwise, let's proceed. Okay, let's proceed. Ms. Leger, you ready with the clock?
Yes, I am.
Okay. Is there a representative from the Sheriff's Department or Sheriff Paul Miyamoto or Mr. Wilson, James Wilson?
This is Allison Lambert on behalf of the Sheriff's Department.
Okay, thank you very much. Okay, Petitioner Anonymous, you have 5 minutes.
Thank you very much.
This is for file number 19143.
Thank you. Ms. Leger, please let me know when I may begin.
Yeah, go ahead.
Thank you very much. So this is only the first complaint, and it is on page P714 or page 88 of item 6. Basically, I had done my standard 10 to 20 sent me emails, 10 to 20 received emails, the department head, and a future and past 1 week of calendars of the sheriff. They responded, their IDR was untimely responded to. And the big thing here is that they basically, their response cites almost every CPRA exemption instead of reviewing the records and only citing the specific exemptions that apply. And when they cited all of those exemptions, they also cited a number of exemptions that are not allowed in San Francisco. And so I've listed them here. The CPRA requires you to, quote, provide a reason, for why records are disclosable. I don't think citing all possible exemptions is, in fact, a reason. It also doesn't constitute the written justification for withholding. They've already admitted that they untimely responded to the IDR. They've admitted the unlawful use of deliberative process privilege. They do not admit the unlawful citation to Government Code 6255, an impermissible balancing test, but it's literally right in there. They claim, as those other agencies have claimed in the past, that, well, balancing tests are sometimes allowed. Whether some other balancing test is allowed is not at issue here. They claim they are using the one under 6255, which is explicitly prohibited by the Sunshine Ordinance in 6724 G&I. And finally, they cite that all drafts are exempt. That's not true. In San Francisco, that all draft CPRA exemption is not valid, and only a very small subset of drafts can actually be exempted. And I guess in this complaint, that's all that matters. And no, I was asked this during the complaint committee. Metadata and other things aren't relevant here. We're just talking about this fact that they believe they could use all these different CPRA exemptions when they cannot. And they've admitted some of these violations and not admitted some of them in their response to you. Thank you very much.
Are there any persons or witnesses providing facts or evidence on behalf of the petitioner and complainant? Okay, hearing none. Sheriff's Department, Ms. Lambert.
Thank you, Chair and committee members. This is regarding complaint number 19143. The Sheriff's Office has taken remedial action on how all public records requests are handled. We've implemented new practices and procedures to improve our response times and responses to all public records requests. We have learned from our errors in responding to Anonymous's public records request. And since the records request at issue came up, all 3 staff members have attended public records courses offered through the California Peace Officers Association 16-hour training class. And as of the middle of June 2021, the Sheriff's Office has implemented a new public records portal. It is public records management software to help us streamline and keep better track of our responses and requests. This type of error that occurred with the response to this public records request is not going to happen again. We are making every effort to be in compliance with the San Francisco Administrative Code and California Public Records Act. Thank you.
Thank you. Any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, hearing none. Members, Questions and answers, clarifications? Vice Chair Yankee.
Thank you. First of all, I would like to say that I think this is the first time I've ever heard that a respondent has actually sent folks to additional training, and so I just wanted to recognize that. I think that's commendable, and I appreciate that. I guess just my simple question would be: are there any portions of the presentation made by Anonymous and the violations that he alleges that the sheriff's department does not feel are proper allegations?
I would like to respond that the letter that is sent out to acknowledge public records requests, the one that Anonymous has objections to and the allegations to, we have stopped using that letter in its entirety. Staff that is assigned to public records consults with our legal counsel before we ever cite any exemptions and looks at and reviews records before any type of denial letter is sent out. So the denial letter that was originally sent in response to this request it's no longer in use. Thank you.
So just to make sure I understand. So like I said before, I really appreciate the work that the sheriff's office has done here to make corrections. But at the time of this alleged violation, it sounds like you're pretty much admitting that the violations that Anonymous found at that time, you're acknowledging them?
Yes, this predates my coming to this position in the office. So
okay.
I can only say that it went out before I started.
Gotcha. Okay, thank you. That's all I had.
Member Stein.
Yeah, so I was actually going to ask Ms. Lambert if they still mentioned possible exemptions in their letter, but I think she spoke to that. So I guess I have a question for Anonymous, which is, have you seen a current copy of the letter, and would you concur that they're not sort of preemptively trying to mention all possible exemptions?
Thank you for that question. I would have to demonstrate what they did after they claimed a change in the next complaint, which is why I was asking them to be combined. But yeah.
Okay.
If you want me to go into that, I can.
Yeah, could you just answer that question?
So in the next complaint, you'll show that they didn't give any justifications. They would just give records, and then there's no justifications, no keys, no nothing. So.
No, not justifications, but I mean, have you seen their revised sort of form letter that they send to people that mentions possible exemptions that they might invoke in answering a request?
No, I haven't, because I think they've changed the procedure, as they told you, to committee twice, once after this complaint and once after the second complaint. So I haven't seen after that.
I'm just wondering, maybe for Ms. Lambert, if it's possible for us to get a copy of whatever generic letter they send now when they get a complaint.
Yes, it's public record, so I certainly would be happy to provide any number of our standard response letter to the committee.
Okay, thank you.
Member Schmidt.
Yeah, it's first, I want to ask a couple questions of Anonymous just to make sure that I'm clear on the scope of what's going on here. It sounds like only 6255, that specifically the deliberative process privilege, that's the only balancing type of state law that you feel is implicated in this case. Is that correct?
No, it is. That is not correct.
Okay. Are they asserting other balancing tests that you contest with regards to the matters in this case?
Yes, they are. At least at the time when they responded to me, they were. So that's bullet number 3 and bullet number 4. So they said, we will not produce documents exempt from disclosure under the deliberative process privilege. That's one thing that's prohibited in San Francisco. And then they had a separate paragraph that says no documents will be produced where the public interest served by not disclosing the record clearly outweighs the public interest by the disclosure of the record under Government Code Section 6255. And those two are explicitly banned by G, H, and I. You're asking, I'm not in this thing, and nor were they raising about official information privilege and other types of possibly balancing tests.
Okay, so we're not in that here. I know we'll get to it at some point, but we're not in that here. I just want to make it clear because at some point, I think there's going to be some law that's going to have to come out on some of these state balancing issues, and there may be disagreement, etc. The second thing of 2 for you is in the record, I noticed that at page 679, you took this to the supervisor of records, and they invoked the rule of reason. Am I correct on that?
They invoked the rule of reason? The supervisor of records did?
I believe that you got a letter, and I'm.
What page is that?
679 in this record.
Oh, yeah, I see what you're saying. So this is badly threaded. That is a response on their ability to respond to a petition, not about the records at issue in this request. It's about the city attorney's response to the petition.
Okay, so, but that in itself, do you feel that their invocation of the rule of reason was in compliance with Sunshine?
I don't think I can argue that in this complaint because the respondent isn't the city attorney's office.
Oh, so, I know you're not. I know you're not bringing that right now, but do you feel like there was a violation there by the supervisor of records in those circumstances by invoking the rule of reason?
How is that relevant to the sheriff?
I'm sorry, could I just get an answer from the witness, please?
I don't know. I have to decide whether I want to. I did not dispute it at the time, if that's what you're asking. I did
okay.
Not. That's in January 2020, but
yeah. If the chairman wants me to, I don't have any further questions.
If you can answer my question, how is that question regarding what the city attorney responded to relevant to the actions of the sheriff?
It's relevant because I want to know. Do I have to somehow demonstrate relevance from my questions?
Not necessarily, but unless it's way off topic.
Okay, so you're asking me, like, you're pre-clearing my questions?
I'm not pre-clearing your questions. I'm asking a question now of how is that relevant? Maybe it's of interest for the rest of the task force to know.
Because I want to know if this person considered and maybe made a complaint, because the rule of reason, I think, being invoked there is very questionable. And so I want to point that out. That's why I think it's relevant.
Okay.
Yeah. So that's I don't want to get deeply into that. I just wanted to ask that one question about it, Chair.
Okay. May I clarify my response?
Please do.
Go ahead.
I want to be clear. I did not concede that it doesn't violate the rule of reason. I said I did not file anything at the time, and I haven't considered it. So I want to be clear. I'm not conceding something in the future. Thank you.
Okay. Okay. Thank you. Thank you. No more questions for me.
Okay. So I'm going to ask you, Petitioner Anonymous, on page 678, that thread what is that all about? Why is that in the record?
I mean, I don't know why things go into the record or not. This is, I need to read what this is. This is a email that's me responding to Cheryl Leger when she was sending me a response from the sheriff's department, and I just replied, and that's the remainder of the thread.
Okay, so that made that particular response is, I mean, it says here on January 4, on page 679, January 14, 2020. It's the subject line was complaint filed with the task force, file number 19143, which is this one. A response by San Francisco Sheriff's Department, Dear Anonymous, and then attached is the response from the Sheriff's Department to your complaint. Okay, so on January 13th, there's a response. There's a response from Bradley Rusi from the city attorney's office. Was that in particular directly particular to this case?
I don't know. I mean, I am guessing, but I don't know that he's responding to a petition about these same records that I sent to the supervisor of records. That's my assumption, but I can't be certain because it doesn't tell me who it was, when it was, like who it was sent to or anything. So
Okay.
It just has a subject line.
All right, thank you. Ms. Lambert, I'm sorry, what is your rank again, please?
I'm a civilian employee. I'm a legal assistant.
Oh, okay, thank you. When you were mentioning about the additional training, has Sheriff's Department done a review of whether employees have also completed the Sunshine Ordinance training?
I do not know the answer to that.
Okay, thank you. Any other questions or clarifications? Okay, are we ready for rebuttals? Okay, let's go with rebuttals. Ms. Lambert, you're first. You have 3 minutes for rebuttal. Mr. Leger will tell you when to begin.
Thank you. The Sheriff's Office wants to reiterate that we've taken remedial action and are no longer claiming blanket exemptions to any and all public records requests. Thank you.
Thank you. Petitioner Anonymous, you have 3 minutes. Wait for Ms. Leger. Thank you.
Go ahead.
Thank you very much. They are correct that they claim that they are now no longer doing any of these things, even though I think in their original response, they were only willing to admit some of them. So it's great. That's good to hear. I don't know that myself personally. I think one of your members asked them to give you that letter. And that's great that if maybe, I assume that kind of thing review would happen at compliance if you agree with me that there was a violation here. I would simply ask that you find the violations on page P714, which is page 88 of the PDF. Citation to written justifications that do not apply to the responsive records, untimely immediate disclosure request response, unlawful use of deliberative process privilege, unlawful citation to Government Code 6255, an impermissible balancing test, and unlawful citation to CPRA draft exemption. If there's any confusion on that last one, they are able to cite the far narrower version of the Sunshine Ordinance's draft exemption, just not the fact that all the preliminary drafts and memoranda are exempt. And that is, and please do send it to compliance so you can review what they're doing now. Thank you very much. I'm done. I don't know if you guys can hear me, but thank you.
Okay, thank you. Okay, members. Any further discussion or motion? Member Stein.
Yeah, so, you know, my understanding is he's asked, Anonymous is asking for a violation of 67.25, 67.27, and 67.24. I just want to say I'm more reluctant on this idea of a violation of 67.24, this which talks about the kinds of public information that must be disclosed, because although I don't think the sheriff's office was correct about the exemptions they were saying might apply to a request, I think it is kind of, I mean, it's not great practice because it might turn off some petitioners, but I think what they were saying in that letter is that these are exemptions that might apply. They weren't citing them as exemptions that they were using or utilizing in any, you know, in this particular case or any particular case, right? So it wasn't that they withheld information for these reasons. They just said these are reasons that might apply, and they were incorrect, but I'm not sure that that's a violation of 67.24 because they didn't actually use those exemptions. That's just all I want to
So you're basically refuting that they admitted it by mistake?
I'm saying they wrote a form letter that said, oh, we've seen your request, and in replying, we might take this slew of exemptions into account. They were incorrect about what some of the exemptions were, but they didn't take them into account.
Yeah, but was that in response to the request?
My understanding is that I read the letter,
Hold on.
is that they list out all these exemptions that they say in like one of the later paragraphs may apply. They don't say like these are exemptions we are applying. They've applied in this case.
My question is are you stating that that was what they said to the requester, or was that what they are telling the task force as their defense?
I'm just saying that I'm not seeing necessarily a violation of 67.24. They said this to all the requesters. They sent out a form letter. They said these exemptions might apply. These are, these are potential exemptions, but they don't say that we are using these exemptions in any, in that requester's case or anybody else's case.
But my question is are they using that as a defense here before the task force? Are they saying to us they didn't provide, they weren't providing these records because of that?
I don't think they are.
Okay, because that's what we're, what they tell the requester is one thing. What they tell the task force is their actual reason for not disclosing the records. Now, if they tell us that at the time before, as the agenda is being created and they're requested to provide their response, and it's in there, then we can determine whether that was correct or not. They could say whatever they want to the requester, and whether that's correct or not is part of the complaint. So I'm trying to discern.
I don't know how I can be more clear, but my understanding of this case is that Anonymous wants us to find a violation of 67.24, which talks about the different kinds of information that must be disclosed, because in that form letter, they suggest that they would hold those exemptions, or they would utilize those exemptions in some cases.
Okay. I guess what the big concern I have here that's missing from this hearing is that we're not hearing from the sheriff's representative what exactly their defense is. So if you look on page 773.
No, but to me that would be about not offering justifications for withholding. That's 67.27. Okay.
I'm going to make a tertiary comment here.
Okay, sorry.
The comment is we did not hear from Ms. Lambert, the representative from the sheriff, what the response is from the sheriff's department. as far as what their defense is for either they are pleading no contest, or are they citing certain sections of the code in defense of not providing the information properly that the complaint is about, so on and so on. So what I'm saying is that if you go to page 773, that is their response to the task force. Essentially, should have been, well, actually, Ms. Lambert's signed it there. So this was her writing. So they're citing that the requester was provided all relevant response records according to their request just 2 days later. So they're saying that they did not violate 6725. I mean, I don't necessarily have to or want to make their case for them, okay? But it's all listed here. The question is whether you're refuting any of those citations, which it sounds like you are, for 6724. Was there a particular?
Sorry, I'm looking for page 773 because
It's printed on the PDF as 773 at the bottom. It's PDF page 147 out of 242.
Yeah, I'll have to look at that. You can go on. I just
Okay.
At that point.
Okay. So, Member Schmidt, go ahead.
Yeah, I would say that we are looking at a 6255 citation and a deliberative process privilege citation, and there seem to be violations in citing those. I think if we make it clear that we're finding violations of those two, then that's maybe what would belong in a 67.24 violation, in maybe also adding in unlawful citation to the draft exemption. That I'm not sure if that belongs or not, but I don't know if we have to get into 1040 and all these other things that really are not part of this, as far as I can tell.
Would enjoy a motion. Go ahead, Member Schmidt. Raise your hand.
No,
okay.
Just load. Okay, I'll be happy to make a motion, which is pretty much down the line of what's requested, although I'm going to make some small edits. 6727 citation to I'll just say written justifications that do not apply. 6725 untimely IDR response, and then 67.24 violation involving the deliberative process privilege, citation to government code 6255, and to the draft exemption in the CPRA. So those are the violations that I see, and that's my motion.
Okay.
Can I just get some clarification on that? You are moving to find a violation of 6727 for written justifications that do not apply, 6725 for an untimely response, and 6724 for the deliberative process. Is that correct?
Yeah, deliberative process privilege citation. Citation to 6255 government code. and also citation to the CPRA draft exemption, improper citation.
Is there a second?
This is Member Neighbors. I'll second.
Moved by Member Schmidt, second by Member Neighbors. This is defined in violation of 6727, that written justification does not apply. 6724, deliberate process was incorrectly applied. That's the 6725 on timeliness. Okay. Any further debate or discussion on the motion to find violations of these three sections? Okay, let's go to public comment. Is there any public comment on the motion? Public comment on the motion. Okay, last call for public comment. Okay, public comment is closed. Any further comments, discussion, members? Are we ready for a vote? Okay, please call the roll.
Member Schmidt?
Aye.
Member Schmidt, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Padmanabhan?
Aye.
Excuse me, Member Padmanabhan, aye. Member Stein?
Aye.
Member Forsley, absent. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find for 6727 of written justifications that do not apply, 6725 for an untimely response, 6724 for the deliberative process incorrectly applied, and Government Code 6255 improper draft of exemptions. Second by Member Neighbors.
Thank you. Please call next item.
Item number 7, file number 20009, complaint filed by Anonymous against Sheriff Paul Miyamoto, Lieutenant Quantico, and the Sheriff's Department for allegedly violating Administrative Code Section 6726 and 27 by failing to justify withholding and keeping withholding to a minimum. It is the same preamble as the previous case.
Okay. Let's hear from the, first of all, Member Schmidt, is there anything you want to present on behalf of the complaint committee?
Just quickly that I think this one is also, the sheriff has, Sheriff's Department has acknowledged that they're making changes, which I certainly commend. And so I think there's also going to be, you'll see that there's some acknowledgement that they didn't properly redact and then give citations for the redactions on a lot of these documents. I think that's pretty much it. Anything else, Member Stein, you're here. Anything else that you recall?
No, I don't have anything to add.
Okay, thank you. We'll hear from the parties next. I imagine both parties are still here. We'll start with Petitioner Anonymous. Mr. Leger, please wait for Mr. Leger and the clock.
Anonymous, you ready to speak?
You have 5 minutes.
Yes, I am.
Go ahead.
Thank you very much. If you still have the previous case open, I'm not sure why, but I put these in both files. It doesn't seem like the presentation for this one is showing up in item 7, but it is in item 6, page 89. Even if you can't see it, this is a very simple complaint. Once I realized what they were doing with these cover letters to me, I actually requested all of their records request responses to all other people for about 1 year back, and to see how extensive this was, who else was getting this. And I believe every single requester had been getting this for at least the past year. And when they gave me those records, which are the records about their responses to other people, they didn't keep their redactions. They didn't justify at all why they were withholding information. And as I believe they also acknowledge, they had withheld the names of the records requesters, which is not exempt. I do have a supervisor of records response, and I don't know if it's actually in here, not against the sheriff, but against SFPD, where they say that records requesters' names are not private and should be disclosed. That was not a ruling against the sheriff. I'm just telling you because that's a ruling that the supervisor of records has made, and I think they accept it. So it's pretty simple. They had stopped by this time using those blanket exemption letters at this point, and but instead now the new problem was they weren't giving any justifications or any redaction keys, which is, I think they're going to tell you they revised their procedure again after this complaint. So the 3 violations I would ask you for are 6726 for failure to provide a key or other clear reference from redactions to justifications, 6727 for failure to provide written justification for withholding, and 6726 for non-minimal withholding for redacting the names of records requesters. I don't believe there's actually on this one anything in dispute unless they're claiming still some of those names are exempt. And they made some sort of argument like that possibly at the committee, where if it's a prisoner, there's some extra exemption applies, but I'm sure they'll explain to you if they're still, I don't know if they're still arguing that exemption for prisoners who make records requests. Thank you. That's all. Thank you.
Okay, thank you. Are any persons or witnesses providing facts or evidence on behalf of the petitioner, complainant? Hearing none, I imagine the same representative, Ms. Lambert. You have 5 minutes.
Yes,
Please
thank
wait.
you.
Please wait for Ms. Leger.
Go ahead.
Thank you. This is Allison Lambert on behalf of the Sheriff's Office regarding complaint number 2009. We reiterate that the Sheriff's Office has taken remedial steps on how all public records requests are handled. The history behind this request is that it was received on a Saturday. Seeing that it was an immediate disclosure request, we went ahead and tried to respond as quickly as possible, and later offered to send justifications, keyed redactions to the requester. Having not heard from the requester, we went ahead and sent an updated production on February the 20th with all of the redactions justified and keyed for the reasons why. In terms of a prisoner making a public records request, we do not release any identifying information on a prisoner that is a criminal history that is exempt from disclosure. And as with the previous complaint, we want to reiterate that this came in while our unit was in the process of receiving training and how to handle these, all of our public records requests. And we're making every effort to comply with the Sunshine Ordinance and government codes. Thank you.
Okay, I'll assume that that's the end of her testimony. Are any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, hearing none, members, the item is with you. Let's see. I have a question for the petitioner, Anonymous.
Yes.
With regards to the redactions, there were as was we just heard in testimony, from the respondent, they said that perhaps some of those redactions were in fact prisoners. Was there any information relating to that that you received from the respondent?
No, so they're not telling you the difference between their two responses. They responded to me, responded to my request, redacting all, without any justification, without any keys, all names of records requesters. Then I filed a complaint, and then they went back after that complaint and did this other process of only redacting prisoners' names. And it does sound like they are still holding those exempt under CLETS.
Okay, so I'm not sure what your complaint is focusing on. Is it focusing on what they provided you first and then corrected, or what they corrected later?
As always, it is, my complaint is written as it was whatever I knew at the time, which was all the names were redacted at the time, which is why I asked for that in 26.
Yeah, but didn't they make the correction later by making the redactions?
Correct. They have now. They're now saying only prisoners are exempt, and that's their argument now. So they've gone back and taken away the redactions on every name that is not a prisoner. I believe their argument is. I don't think that the prisoner name is exempt under CLEPS. It's just someone happens to be a prisoner when you send a records request.
And when did you receive those corrections?
After I filed my complaint.
After you filed your complaint. Okay.
That's correct. Yeah.
Got it. Okay, that was what I was getting at here.
Yep.
Okay. All right. Are you talking about the responses from the Office of the Sheriff starting on page, it looks like 33 out of 242?
Let me get to that page. Sorry, the PDF number is what?
The PDF printed on the page is 659. The page, the actual page is 33 out of 242.
Yes, that's correct. And yeah, that's their that was their response to me before I filed the complaint. They just redacted all of the names everywhere with no justification or keys. Correct.
Got it. Okay. And Ms. Lambert, are you aware of the requirement?
Yes, we are aware of the requirement that the Sunshine Ordinance requires that there are justifications or footnotes for anything that is redacted.
Okay. Thank you. Member Schmidt, go ahead.
Yeah, just specifically on the CLETS issue. Question for Anonymous. Do you want to assert here that there was a violation by withholding that information under the CLETS exemption or objection?
So again, I don't know what your rules require. I originally said it's just about all the names being redacted. That's all I knew at the time of my complaint. If you're asking me now that I know they only want to withhold the CLETS names, yes, I would still argue that I don't think that if I'm a prisoner and I send a letter to someone, my name, just the existence of me being a prisoner, is CLETS information. I believe the CLETS exemption specifically exempts information derived from a specific law enforcement database that is shared amongst various agencies. And I don't think just because someone's a prisoner, that means it was derived from that database. Thank you.
Okay. Yeah, I think that I'm with you on that argument. I wanted to figure out if that's what you wanted as part of our order. Ms. Lambert, would you have any substantive response on that legal issue as to why CLETS is a valid exemption basis in this case?
At the Sheriff's Office, we can only confirm if somebody an inmate's records if they are currently in our custody. So anytime that we release any kind of information about anybody who was formerly in our custody, we consider that criminal history information, and we are not able to release that. Once they leave the sheriff's custody, we cannot release any more information about their identities because it's criminal history.
Okay, and so you're saying that it applies to some of the deletions that
There
were
was actually just, I'm sorry to speak over you, there was actually just one PRA from an inmate. So we're talking about one record.
Okay, just one in the batch here. Okay, thank you.
Correct.
Thank you. I appreciate that.
Member Schmidt, can you or a petitioner anonymous or respondent Ms. Lambert explain what and for our own edification what the CLETS provision is?
Who would you like to answer that?
Well, whoever, if you're all talking about it. And for the edification and education of the rest of the task force and the public, I think it's worthwhile to mention, to describe what that is, because we have no reference of it.
I'm happy to if no one else wants to.
I would defer for now because it seems like, I guess it's an issue here. I was trying to figure out if it is an issue, and it sounds like it is. So let's allow the parties anonymous.
Okay, go ahead.
Sure. So CLETS, I apologize for speaking over you. CLETS stands for California Law Enforcement Telecommunication System. There's a special exemption, I believe it's in the penal code, that allows you to not provide any information from that database or derived from that database. And I don't see how that applies to the fact that a prisoner happened to make the request. The actual part of the response that may be that person's criminal history or law enforcement database derived information, I'm not contesting that. Just their name. You don't have to give me their prisoner number. You don't have to give me anything else, which prison they're in, just the name. That's all. Thank you.
And Ms. Lambert, can you expand on why you applied that and how it's applicable to this request?
Yes, our policy with the sheriff's office is we will not release any information on any individuals who are no longer in sheriff's custody. So we, once somebody leaves the sheriff's custody, we cannot identify if, they were ever in prison. It was considered criminal history, and that is why we will not release it.
So you're saying that if a prisoner were to make a PRA request while they're incarcerated, that is exempt. Their identity is exempt.
No, if they are still in sheriff's custody, then their identity would not be exempt. So it does change. So say the request came from a former prisoner, we would not release that former prisoner's identity because it is criminal history information.
Oh, I see. Okay. How would anyone know that they were a prisoner?
I'm sorry?
How would anyone know from the information on the PRA that they were a prisoner?
In this particular instance, there actually was an inmate number following the individual's request.
Okay, and so if you redacted that and not their name and keyed the citation correctly, would that not be sufficient?
I don't believe so.
Okay, thank you. Okay, any other questions? Okay, should we move to rebuttals? Okay, let's move to rebuttals. Ms. Lambert, respondent, you are first, 3 minutes. Wait for Ms. Leger.
Are you ready, ma'am?
Yes, I am.
Go ahead.
Thank you, committee. The sheriff's office offered to provide updated redactions and justifications to the requester. And upon not hearing from the requester, we went ahead and did this anyway in conjunction with updating our procedures for handling public records requests. Thank you.
So when you're finished with your testimony, petitioner, you have 3 minutes. Wait for Ms. Leger.
You ready, sir?
Yes, I am.
Go ahead.
Thank you very much. I want to clarify again, because I don't know why they're not making it clear to you. That was only after I filed a complaint that they offered to do this, and then they did it. The point, as I've made in now, I don't know how many complaints, and this task force has discussed, you have to follow the Sunshine Ordinance, not because some magic words are issued, not because Anonymous knows how to file complaints, but for everyone, for each request. And when you respond and you redact something, you have to key that redaction. I don't get special privileges because I know how to file Sunshine complaints. The point is everyone gets this for every request, every time, and not because it's optional. In fact, I even discussed at your education and training committee, there's even training from a city lawyer that says the rule automatically applies. There's no invocation of the Sunshine Ordinance. Anyway, so 6726 for not not keying the redaction, 6727 for just not providing any written justification at all, but 6726 for non-minimal withholding of the names, which they admit because they changed it. And then the only real question, I think, is I would say that what the chair and member Schmidt has said is correct. This information, you don't need to give me the criminal law enforcement information. You don't need to give me any history. But if I'm just a random person who used to be a prisoner in the jail, and now I make a records request, why my name would somehow be magically exempt doesn't make a lot of sense. I don't see how that has anything to do with criminal history. I'm not asking you to give me that person's criminal history. Just redact whatever you think is criminal history, prisoner numbers, whatever it is, and just give me the person's name. But even if you don't agree with me on the fact that that is not a valid Quest exemption, you should agree with me that all the other names should have been provided initially as well, as it would appear that the supervisor of records agreed in the case with SFPD. Thank you very much.
Okay, so the item is now back with us for debate and a motion. Member Schmidt, you have your hand up.
Yeah, just that I think I would back up the anonymous side on that Kletz issue. And I think it may be a good idea that we note it in an order if we do have an order on this, because it just doesn't seem like these letters and the names on the letters would be covered by that exemption.
Okay, thank you. Anybody else? Is there a motion? Is there a motion? Member Stein. You're muted, Member Stein. You're mute, Member Stein, you're muted.
Okay, how is it now?
Yes, we can hear you.
Okay, sorry. So I will make a motion to find a violation of 67.26 and 67.27 for failing to justify withholding and keeping withholding to a minimum.
This is Member Wong. I'll second that motion.
Okay, moved by Member Stein, second by Member Wong, to find violations 6726 and 6727. Can you give a little just narrative as to what actions you're finding the violations for each of these? We've been requested by many members of the public in the ODs that they're not descriptive enough.
The information was, I'm there, right? The information was redacted with no explanation or improperly redacted with no redaction keys, that the names of requesters were withheld.
And for 6727, is the same thing, no justification for the withholding?
Yeah, I mean, no, that was to cover both of them.
Okay, got it. Okay. I would just ask, is there a timeliness issue here? So it seems on I think what I'm looking at here on, let's see.
It was filed on December 7th and it was received on December 18th, right? It was an IDR.
Right. I think that's the right one. Everything's better there. It's hard to separate which one's which from these. Let me just get clarification from the petitioner. Can you point us to the page for 20009, this case, this file number, with regards to the when you file the request and the chronology thereafter?
I can tell you there is no timeliness violation, and you can see it, and I haven't asked you for one. It's on P875. I made the request on January 11th. They responded January 14th, but there was a weekend in between, so there's no timeliness issue.
Okay, great, thank you. It's just because the other file is also all together with this, so it's hard to tell. Okay, very good. Okay, any last thoughts, members? Okay, let's open up for public comment. Ms. Leger, hand it to you.
Just a second.